Sergeant Major Troxel. This is Staff Sergeant Retluski. I hope this video finds you while you are still the senior enlisted advisor, because I can assure you at this point, if you are what America needs. And if you've retired, well, you're just another veteran like the rest of us. We're glad to have you. But we could really use your authority in the office you have now. And I'm sure, Sergeant Major, if you turn around, you see that American flag got gold fringe on the bottom. And for those who don't know it, that is his flag next to it. The Sergeant Major is a flagged officer. And we may need that because, well, he's the senior enlisted advisor. And of course, he would know. And anybody who served enlisted, this is the oath that you took. And without going through the whole thing, just say, and that I will obey the orders of the President of the United States. Orders of the President of the United States. Now, where would those come from? Well, I'm going to show you where they come from. Right here. Process and mandates. All process of this court issues in the name of the President of the United States. What court are we speaking of? Well, of course, it's the Supreme Court of the United States. So two things to know if you're a veteran. Number one, you can take your case to this court for free. It's in Rule 40. And number two, all of its orders issue in the name of the President of the United States. And those are the orders that all enlisted have taken an oath to follow. The orders of the President of the United States. Well, then they're going to come from the Supreme Court. And because the flag, this United States flag here behind the Sergeant Major, it's got gold fringe on it. Well, that's evidence that we're under martial law. It's not a Navy flag, it's an Army flag, or it's an Army version, militarized version of the national symbol. And it can only fly in military establishments or places under the military, for lack of a better term. So if you go in a courtroom and see a gold fringe flag, well, that means the federal law applies there, and that's a military flag, and that's a military courtroom, because that flag would fly in a military courtroom. So it's a crazy world we live in, Sergeant Major. I don't know if they teach this in Sergeant Major school, but I want to show you a few things. So thank you for your time, and I'll just get on with my presentation. Give me just a second, please. Okay, so my prayer is that somehow this video gets into the chain of command in the United States Armed Forces and makes its way to the senior enlisted advisor, to the chairman, which at the current time is Sergeant Major, Command Sergeant Major John W. Troxel. And that he takes his flag and goes to the Supreme Court and plants it next to their flag, which would be this flag here with gold fringe on it, and gets some orders to go and round up the usurpers that are pretending to have authority under the United States, but they don't, because they don't have proper oaths of office. Or, as I'm going to show you in a minute, they don't have a proper civil commission for the office that they hold. And so, without any further ado, my idea is to take it to the general, petitioning for redress of grievances. Now, this isn't the general as in the, Army general. Well, I guess it probably is. This is the Solicitor General, who has an office in the Supreme Court. And what we're having a problem with, Sergeant Major, is the people of the United States petitioning for redress of grievances against the Constitution. Right? The grievance is somebody's doing something wrong against the Constitution, and nobody will do anything about it. And you've been insulated in that wonderful system of the United States Army, but you get out here in the real world, you're going to see that it ain't quite what it appears to be. And, it's a Talmudic law system. I've done a lot of videos on this. I don't know how much to say again. I just get tired of talking about it all the time. But over the last couple of videos I did, which would be you cannot impeach an imposter, I declare for declaratory judgment, and Court Rule 40, right to petition the government, all tie together in this idea that people aren't who they say they are. We're trying to get a declaratory judgment on issues that have to do with things like this. And, well, if you're a veteran, Court Rule 40, the Supreme Court says you can send your stuff to them for free. And what we want to do, according to the Supreme Court, is petition for a right for redress of grievances, which is a First Amendment right, which is being violated because it's a procedural right, and no one will tell us the procedure. See how simple it is? That's the problem. No one will tell us how to do it. It isn't that we don't know how. It's just no one will tell us how it needs to be done for them to say, hey, that's a petition for redress of grievances. I have to pay attention to it. They act like it's, foreign news to them. So in this particular case, if you went to the Solicitor General's website, or page on the Department of Justice website, you would find a history of the Solicitor General's office written by a Solicitor General back in 1998 or something like that. And some of the points that are in there are that the Solicitor General is the only officer of the United States required by statute to be learned in the law. Well, that has significant meanings when you're talking about the law. He is one of only two people, other than the Vice President, being with a formal office in two branches of government. Well, that's interesting. Right? The Vice President, he's in the executive and the legislative, because he's the President of the Senate. So the Solicitor General, he's in the executive branch, but as it turns out, he has an office in the Supreme Court building. And with respect to the Supreme Court, the Solicitor General has often been called the 10th Justice. Interestingly, it also mirrors the very responsibilities given the Attorney General himself in 1789. So they're talking about, at this point in the discussion, the creation of this office called Solicitor General by the act that created the Department of Justice, and that he is the Attorney General when the Attorney General has a disability or is vacant or whatever it is. And well, that's what they've done, right? Because to be the Attorney General, you had to be learned in the law. That was from the original, and it doesn't say that anymore. So he's not qualified. The person holding the office of Attorney General isn't qualified to perform the duties of the office of Attorney General. Actually, the person who is the Attorney General isn't qualified to hold the office of Attorney General. I guess that's the way to say it. Right? So if the incumbent isn't qualified to perform the duties of the office of Attorney General, then the person that would be the Solicitor General, according to the act that created the Judiciary. Not the Judiciary, the Department of Justice. Anyways, although given broad authority over legal affairs of the country, the Attorney General, unlike his fellow cabinet members, did not preside over an executive department. Rather, the Judiciary Act of 1789 created only the office of Attorney General. So, if the Attorney General isn't there, because he isn't qualified, then he isn't a cabinet member. The cabinet member is going to be the Solicitor General, acting as the Attorney General. More on that in a minute. Hey, I call myself Rob Ryder. My email address is courtofrecord@aol.com, and my phone number is 616-712-6179. And please donate before I have to beg, if you can. I spent all my time doing this, and I'm going to show you some things that I think blow your mind, and I would hope that has some benefit. And if nothing else, have some value. So if you could, please donate. You could do that by PayPal to Rob Ryder, ROBBRYDER @AOL.com. Walmart, Western Union. Send it to me in the mail at Robert Allen Retluski, RYTLEWSKI, 10955 14 Mile Road Northeast, Rockford, Michigan 49341. Okay, so the way I want to show this information is by what I've already done so that I can make public record of things I've already submitted to try to petition for redress of grievances, as I said that I would at my last video I did 4 days ago. So this is what I had done just prior to that and since then, and well, here's where we are. So this one's brand new, just went out today. All right, so this is where I've decided, okay, I'm just going to petition to the Solicitor General of the United States. Him representing the federal government of the United States, right? So people in the United States, that would be the sovereign, ex-rel Robert Allen Rutluski, veteran, well, I'm their relator, right? And going to the federal government of the United States, ex-rel Solicitor General of the United States. Counterfeit commission. Counterfeit commissions of judicial officers. Yes. Petition for redress of grievances in accordance with the First Amendment. So I sent this by email today to 3 different email addresses at the Supreme Court and one at the Office of Solicitor General. You know, to me, it's a notice to agents, notice to principal. The man has an office in both the DOJ and in the Supreme Court, so I'm sending it to both and letting him know that there's counterfeit commissions of judicial officers. So I have attached to this email a FOIA reply from U.S. Department of Justice for a FOIA request received in this office on September 14, 2018, seeking copies of commissions of judicial officers appointed by President Donald Trump. Now, I'd like to say at this point that it said September 14, 2018 is when they received it, and they're just now frickin' answering. As we shall see. All right, here's the FOIA, May 29, 2019. Hey, thanks, there, DOJ, for getting around to it. Where you said this responds to your Freedom of Information request dated August 25, 2018, seeking copies of commissions judicial officers appointed by Donald Trump. Actually, Donald John Trump. There is no Donald Trump or no Donald J. Trump. These are all parts of the problem. But anyways, Rosita had put this in, and lo and behold, if we don't get an answer, and thank you, Rosita, for putting this in, because look at what we got. So this is supposed to represent a commission. Let me blow this up a bit. Donald J. Trump, President of the United States of America, to all who shall see these presents, greeting. Know ye, very special trust, confidence, wisdom, uprightness, and learning of somebody of Indiana. Yada, yada, yada. Going to make them a office according to United States Circuit Judge for the 7th Circuit. Okay, that's what this commission is supposed to be for. Saying that Amy is going to be a circuit judge. And there's Donald Trump's scribbles. He's got the Attorney General here with the seal of the Attorney General's office. Well. I'm afraid to say that there's just a few things wrong with this. So let's go through what those are, and then I'll go show you where we can see exactly. I'll just finish it. So take notice that the copies of the commissions, which there were like 71 of them, provided by the Department of Justice are evidence of counterfeit commissions. The individuals named on the counterfeit are falsely claiming authority under the United States and usurping of the sovereign power of the people of the United States. From Marbury versus Madison, which is a case from 1803, which is often quoted by the Supreme Court, and all these blah, 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 when they want to talk about why the Supreme Court can call something unconstitutional, it goes back to Marbury versus Madison. That's what set the precedence for judicial review. Well, that isn't all this thing did. This Marbury versus Madison is just chock full of information of things that had happened, and that's what they were doing, is they were establishing a precedence for all these different questions that would come up about what the hell the Constitution meant. Because everybody wanted to have their own opinion. And that was left to the court to decide, the Supreme Court to decide what the Constitution meant. So in that Marbury versus Madison, now this is the opinion of the court. This is the Supreme Court speaking. One, that by signing the commission, Mr. Marbury, the President of the who? United States. Does not say United States of America. It says President of the United States. Appointed him a Justice of the Peace for the County of Washington and the District of Columbia, and that the seal of the United States affixed thereto by the Secretary of State is conclusive testimony of the veracity of the signature and the completion of the appointment. It had to be done by the President of the United States, it has to have the seal of the United States, and it had to have been affixed by the Secretary of State. Let's go back and look again. President of the United States of America. Well, that would be incorrect. We don't need to go any further. Donald J. Trump. Well, that would be incorrect, because Donald J. Trump is a pseudonym. He doesn't exist. Donald John Trump is the proper identification of the American national who was elected to be the president, but is still president-elect because he hasn't taken the proper oaths of office. I mean, I've done videos on that, Sergeant Major. I am correct. And I'm correct that this isn't the seal of the United States, and this isn't the Secretary of State, so this commission is a counterfeit. Who's ever trying to use this as their authority to do anything should be immediately arrested as a usurper of the sovereign power of the people of the United States and thrown in a FEMA camp. And they're just page after page after page after page of them. And so, I don't know where these come out of exactly, Sergeant Major, out of the office of the Department of Justice, but I know that the Solicitor General is in charge of it. So he should go find out. That's why I take your flag, go plant it by his flag, go have a talk. The following defects are evidence on the attached commission, rendering the document of no legal value. The seal of the United States is not affixed. Department of Justice does not convey authority under the United States. The Secretary of State has not countersigned the commission. Donald J. Trump is a pseudonym. It is not the full legal name of any American national, and its use as identification in an official capacity is a felony omission of material fact. Marbury v. Madison opinion states that the President of the United States is to appoint civil officers. The President of the United States of America has no authority to appoint any officers of the United States. And as I showed before, well, who's the President of the United States? Well, it's... there we go. Let's go find out. Well, I don't know, but you can go to the Supreme Court. You can get an order issued in his name, so I guess you go to the court to find the President of the United States. And, as they said, the Solicitor General's got an office right down the hall. So if you go on the website for Solicitor General, you can read the Solicitor General in historical context, presenting the case of the United States as it should be, but it's not as we find it. But here's the thing about respect and honor to the principle of stare decisis, which is the idea of precedence. And the precedence has been set in Marbury versus Madison that a proper civil commission is done by the President of the United States for civil officers. So, in the name of the people of the United States, I demand the Solicitor General of the United States immediately arrest all usurpers claiming authority under the United States and hold them for trial before a military tribunal. So I'm hoping you can go pick them up, Sergeant Major. Go round them up and take them out. Take notice, the gold fringe flags flying in the Supreme Court's courtroom and all other courtrooms. It's in all courtrooms, Sergeant Major. It's all over the place. Every place you see a gold fringe flag, that's an Army flag. Means the Army's been there. We're under martial law. Have been since 1863, excuse me. Anyways, it is evidence the United States is under martial law and military government. The usurpers of authority operating under the attached counterfeit commissions are enemies of the United States, engaged in domestic terrorism against the people of the United States. Under martial law, or until martial law is rescinded in accordance with Article 2 of General Order 100, the Lieber Code, the United States does not have a functioning civil government, and the United States Armed Forces is in charge of the country. And I am one of the United States Armed Forces veteran members. And as a veteran, you're still in the Armed Forces because you're still subject to the Uniform Code of Military Justice. Once you took your oath of office of enlistment, that puts you in the military, and there's nothing in there about getting out. You're in forever. You're just a veteran, right? You're not on active duty. You're a member of the Veteran Corps. Now, you could be a veteran and be in the military. So, my point is, hey, you're a veteran. We're all in this together. So in the Lieber Code, under Article 2, if you've not read it, it says martial law does not cease during the hostile occupation except by special proclamation, ordered by the Commander-in-Chief or by special mention in a treaty of peace concluding the war, when the occupation of place or territory continues beyond the conclusion of peace as one of the conditions of the same. Well, they did issue a piece of paper that was supposed to have stood for some kind of cessation or proclamation in Kentucky or something like that. Rosita had gotten it, another one of these wonderful finds she had. But it didn't have the proper seal on it. Again, it's just a piece of paper, right? Just because it says it is something doesn't make it so. It has to have these elements on it to have any official capacity. And they don't. So, Solicitor General, the United States is at war and under attack. Do your duty to God and country, call out the army, and quash the rebellion. General, that would mean, well, get a hold of this guy here. Don't know what to do next? Call him. He can take it from there. I'm sure they can come up with a plan. Okay, so I just sent that by email just this morning to the Supreme Court, waiting for an answer. But I had done a couple other ones that, point out some other interesting facts that things are just the way they are. So let's call it what it is and put the truth on the table and see if we can get truthful people to shake off the devil and do the right thing. Yeah, flag of the Senior Enlisted Advisor. D. Okay, hang on just a second. Okay then, Sergeant Major. Unfortunately, that isn't the only defect in our governmental system as it exists today. We're also dealing with this. I had sent so what I had done, first of all, is I'm sending another petition to the Supreme Court. This had to do with the docket I had entered into the United States Court of Appeals for Veterans Claims. It's docket number 19-3537. And sure enough, 19-3537, there it is. Robert Allen Rutluski versus U.S. Supreme Court. Except when they put the parties down, they put my name backwards with a comma. And they put Supreme Court, United States of America, which isn't who I sent it to. I sent it to the Supreme Court of the United States. Somebody's altering my paperwork. That's an error or an omission. It's a false statement in a federal matter. That'd be a violation 18 U.S.C. 1001. Somebody should be arrested. What's the chances, Sergeant Major? But this is what's going on. In here, I was saying that the clerk of the Supreme Court intervened in my procedural right to petition the judiciary branch in its role as a co-equal third branch of government for redress of grievances offending the Constitution when he returned the government's copy of a petition without redressing my grievances. In other words, he sent it back to me. He didn't act on it. The clerk's reasoning was due to limiting the court to its Article 3 powers. I have attached a letter to this email, da-da-da-da. I respectfully object to his reasoning. The submission of a legal petition to the judiciary, acting as the sovereign and not as the sovereign's court, is a constitutionally protected right of the people of the United States. I'm not really going to the court as the court. I'm going to the court as the sovereign's power to handle legal petitions. Right? The people are the sovereign. They have a government they created. Well, the government is split into three parts, or has three branches, but they're all co-equal branches. I'm going to the branch of the government that's supposed to handle legal petitions, which would be the court. This was all pointed out in the last video I did by the court. They won't tell you what it is. What's a legal petition? They try to make it sound like it's a lawsuit, but Scalia caught him on it. To the rest of them said, it's never been, the Supreme Court has never said that a lawsuit is a legal petition. And when he was dissenting in this one particular case. And that nobody countermanded him and said, yes, they did, da-da-da. So my point is, a lawsuit is not a legal petition for redress of grievances to the government. A petition, right? A petitioner and a respondent is how you redress grievances with the government. And since our system is based on the laws of England, in England you would petition the king. So now we're petitioning the government, which is the king's government. And, the king is away. So now the king is away. Right, that'd be Jesus Christ. And so who's in charge? Well, his chancellor would be. And the chancellor is the guy that's over the court of chancery. And as it turns out, a solicitor is a person whose business is employed in the care and management of suits depending in courts of chancery. Well, the Solicitor General isn't a solicitor. He's a general of the solicitors. He's the chancellor, which is the king's right-hand man. When the king is away, the chancellor is in charge. And so what they really did is they put the United States in a little package and they gave it to the Solicitor General. And all this other shit we see is actually United States of America, not United States. United States of America. The United States of America is a dominion of King George III's successors. It was determined back in 1783 in the Treaty of Peace, and it says in the first paragraph that King George III is describing who he is. And one of the things he's claiming jurisdiction over is United States of America. Not with T capitalized, just United States of America. So now go look at your money, pull out a dollar, it says the United States of America. Well, that would be the Republic, created under the Articles of Confederation. First article, the style this Confederacy shall be the United States of America. But United States of America is a dominion of King George III. Those two are in union under the Constitution, which was written to tell the United States of America what it could do while it was here. And it's usurped the powers of the United States and is pretending to be the United States, when in actuality, it's a dominion of Great Britain. So, something needs to be done, Sergeant Major. And it's done through the Court of Chancery, which is what the Supreme Court is. It's acting as the King's Bench and the Court of Chancery. And the guy over the Court of Chancery is a guy called the Chancellor. And the guy over the Court of Law, the King's Bench, is called the Chief Justice. So that's why I'm going to the Solicitor General. That may have got off track a little bit, but hey, That's what happens when you've done too much paper. Anyways, I had gotten this letter from the Supreme Court just the other day for this petition for redress of grievances that I had actually filed into the Veterans Court, because at the time I said, well, I could file it in there for free because I just give them a piece of paper that says that I can't pay the $50. It was after that I found out, well, shit, you just go directly to the Supreme Court for free if you're a veteran. But this was already in play, so I got this letter back that says, reply to your letter received for 2019 or submission. I called it a submission. They want to call it a letter. I regret to inform you that the court is unable to assist you in the manner you present. Under Article 3 of the Constitution, the jurisdiction of this court extends only to consideration of cases or controversies properly brought before it from lower courts in accordance with federal law and filed pursuant to rules of court. The court does not give advice or assistance on answer legal questions on the basis of correspondence. Your papers are herewith returned. The rules of this court are enclosed. Well, my answer to that was this letter that I was reading. So I respectfully rejected his reasoning. I object to his reasoning. The submission of a legal petition to the judiciary acting as the sovereign and not as the sovereign's court is a constitutionally protected right of the people of the United States. I am not filing a lawsuit. I am enforcing the Constitution by ordering actors of the federal government of the United States follow the supreme law of the land and ensure anyone claiming authority under the United States recites, subscribes, and records the proper oath of office that satisfies the 6th article of the Constitution in the individual's full legal name as I fully described in my petition. The clerk impeded my access to justice either by mistake or omission, both of which are unacceptable, but one includes sanctions and a penal, penance, and a FEMA camp. That's for the court to decide at some future time. I ask you be pardoned if you found to be repentant. At this time, I am more concerned with the public information officer relaying to the Solicitor General's office in the Supreme Court building my petition received by the office, and that he advocate for the people of the United States and redress my grievances. Take notice, whoever, having knowledge of an actual commission of a felony cognizable by a court of the United States, conceals and does not as soon as possible make known the same to some judge or other person in civil or military authority under the United States shall be fined under this title or imprisoned not more than 3 years or both. That would be 18 U.S.C. 004. Public information officer, ye now possess this knowledge. In other words, I just made you aware of a frickin' crime, brother, and if you don't do something about it, you're as guilty as the offender. And this is all based on, I had filed a claim in the United States Court of Appeals for Veterans Claims, making the Supreme Court of the United States the respondent. So I mailed a copy to the Supreme Court of the United States. As people of the United States, Robert Allen Ratluski, Relator. And it was received, Office of Clerk, Supreme Court, U.S. I don't know what court that is. I thought it was supposed to be the Supreme Court of the United States. Why are you abbreviating? You guys write paper after paper after paper after paper after paper. I say you're concealing the Supreme Court of the United States behind a thing called Supreme Court U.S. Perhaps that's the military tribunal that's taking the place of the Supreme Court of the United States while the Constitution is suspended because we're under martial law. God. Anyways, hey, claiming a right under First Amendment to petition the government for redress of grievances. Which I put in, I, Robert Allen Ratluski, veteran 8 years active duty service, United States Army, still bound by oath of enlistment, still bound by Uniform Code of Military Justice, still a member of the United States Armed Forces. As relator for the people of the United States, submit this petition to the government as respondent for redress of grievances pertaining to the usurpation of constitutional authority in accordance with U.S. Const. Am. 1 pertaining to persons. This is what they're doing, Sergeant Major. They're failing to recite, subscribe, and file mandated oath of office, oath, to satisfy U.S. Constitution, Article 6, subsection 3. They're filing counterfeit oath, with or without religious test, in offense of U.S. Constitution, 6.6-3, and concealing individuals' legal identity by filing counterfeit oaths under assumed names. They're not using their full legal names. They're doing all these things, and then they're claiming a salary from the government of the United States while impersonating an officer of the United States. The United States Court of Appeals Veterans Claims, proper venue to submit a petition, a legal petition for redress of grievances, as it is a court established by the government with the inherent power under the Constitution to process legal petitions for redress of grievances submitted to the respondent. Supreme Court of the United States has responded. Respondent is appropriate as it is a legal petition, as this is a legal petition, not a political one. The Supreme Court of the United States represents the judicial branch as co-equal branch of government with a duty to declare the law, and it possesses the inherent power to have the law it declares executed and enforced, because it can issue orders under the name of the President of the United States. Facts that substantiate the claim, failing to recite, subscribed, and filed mandated oath to satisfy U.S. Constitution, Article 6.3, and 1 Stat 23, which is an act to regulate the time and manner of administering certain oaths, mandates oath intended to satisfy the 6th Article to support the Constitution. Not complying with this act of Congress is unconstitutional. 1 Stat 23 is an act of Congress. You can look it up. It has in there, it says right in there, this is the oath that satisfies the 6th Article of the Constitution. Tells everybody who has to take it, and that's not the oath that's being taken. The President's oath of office, which is from the Constitution, says, I do solemnly swear or affirm that I will faithfully execute the office of the President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Right? But it doesn't say support. Right? It does not support the Constitution, necessitating the President recite the oath of 1 Stat 23, because the 6th Article of the Constitution only says that you need to take an oath to support the Constitution. Right? To support. It doesn't say protect, defend, it says support. Well, the President's oath doesn't say support. It says preserve, protect, and defend. But it doesn't support, so he has to take the oath that's in 1 Stat 23. The oath of office in 5 U.S.C. 3331 contains a religious test, rendering this statute unconstitutional, and its oath into a counterfeit public security of the United States. That oath says, so help me God, and in the 6th Article of the Constitution, it says there can be no religious test, and the oath says, so help me God. I'm afraid you just violated the Constitution. Right? It's an unconstitutional act of Congress that created it. It's just that simple. The several states' alleged legislative, executive, judicial officers have failed to comply with 1 Stat 23 because they also need to take the same oath to support the Constitution. That's in 1 Stat 23. Belligerents are usurping the authority of vacated offices and collecting its salary. It's really that simple. Filing for record of counterfeit oath or oath with religious test in offense of the U.S. Constitution. 5 U.S.C. 3331 states this section does not affect other oaths required by law. It does not relieve office incumbents from complying with 1 Stat 23. It says right at the end of it, this section does not affect other oaths required by law. Okay, well then you need to take 1 Stat 23. 5 U.S.C. 3331 contains a religious test and is unconstitutional on its face. Alleged members of the United States Congress violate the Constitution when they recite, subscribe, file oath of office, or the oath of 5 U.S.C. 3331, as a substitute for the mandated oath of 1 Stat 23. Persons required to file an oath of office as a condition of employment who file the U.S. Office of Personnel Management Standard Form 61 Appointment Affidavits form as evidence of their compliance with the Constitution have filed a counterfeit public security of the United States. You know, it's a violation of the Constitution, a counterfeit, right? So, again, more counterfeit, more violation of the Constitution. The appointment affidavit bifurcates the oath of office of 5 U.S.C. 3331, which wasn't constitutional anyways, but hell, now we'll cut it in half. Creating a counterfeit certificate of a public security of the United States, relying on the Standard Form 61 appointment affidavit as evidence of authority, offends the Constitution. Concealing legal identification by filing counterfeit oath under assumed name. 5 U.S.C. 3331 is unconstitutional as it requires a religious test. Relying on the oath of 5 U.S.C. 3331 as authority under the United States is falsely relying on counterfeit public security of the United States as justification to usurp the powers of a legitimate office of the United States. Reciting and subscribing an oath of office using any name other than the full legal name as defined in 6 CFR 37.3, which says is an individual's first name, middle names, last name, or surname without use of initials or nicknames, simulates a legal process that renders the people of the United States insecure in their persons, papers, houses, and effects against unreasonable searches and seizures in violation of the U.S. Constitution Amendment 4. Donald J. Trump is not any American national's full legal name, and it is unfit to identify the President of the United States of America in accordance with U.S. Constitution 2.1 clause. It should have been just United States. We'll have to go back and check. No style of name other than Donald John Trump is legally sufficient for his United States oath. The congressional record of January 17, 2019 on pages H712 to 714 evidences the alleged members-elect of the United States House of Representatives recited an unconstitutional oath of office, 5 U.S.C. 3331, and then subscribed the same under an inferior style of name that has no legal standing for use as identification in legal purposes. YouTube provides videos of senators affirming the unconstitutional counterfeit oath of office, as recited to them by the alleged Vice President of the United States, the Secretary of State, and county clerks, or similar office of the several states file counterfeit certificates of oaths that do not conform to the mandates of the state and were sworn and subscribed under fictitious names. It is an omission of a material fact in a federal matter to conceal one's true identity. Claiming a salary from the government while impersonating an officer of the United States. Taxes paid by the people of the United States are paying the salary due an officer of the United States under a false claim of a usurper of the sovereign's power who is obstructing justice by pretending to be an officer of the United States or several states, thus ensuring the people are denied redress of their grievances as part of a scheme to facilitate the people's victimization by false accusers. That's the life in the world, Sergeant Major. There can be no doubt that offices of the United States and several states are vacated by reason of unqualified incumbent who has failed to recite mandated oath of office, failed to subscribe the same in their full legal name, and failed to file a constitutionally valid oath of office. These defects are causing a constitutional crisis and facilitate the ongoing insurrection and rebellion. These usurpers terrorize people in the United States, extort the people's wealth, and seek to poison and destroy the United States and the rest of God's creation, and they must be stopped. Take notice, oath of enlistment is recited and subscribed in full legal name. I, Robert Allen Wertlewski, veteran, and all other enlisted veterans recited and subscribed our oath of enlistment in full legal name, and a veteran non-commissioned officer or enlisted personnel of the United States Armed Forces with sworn duty to support, defend, and bear allegiance to the Constitution. We are the legitimate civil authority of the United States. As one of these people, I order the respondent to declare the law, use the United States Armed Forces to disperse the belligerents, restore civil order, seat the President of the United States of America in his full legal name and provide all other relief available to the people. I certify under penalty of perjury, foregoing is true and correct on 5/27/2019. And I'll be damned if the frickin' clerk of the Supreme Court sent it back to me and said, hey, I can't help you. I can't help you that all that shit's happening. Well, there's nothing we can do. Hey, this guy's using the middle initial too. I think he's a usurper. We seem to have a problem with usurpation of office, Sergeant Major. Something needs to be done. This is why we need to go to the only man learned in the law, in the government, who's holding offices in 2 different branches of government. At least 2. Hell, he may be holding one in the legislature. I don't know. But he's holding 2, and 2 out of 3. Well, that, in a democracy, that's the majority. That's a supermajority, can't be beat. And so, on his word, can be issued an order in the name of the President of the United States for the United States Armed Forces to go clean up the mess. I'm praying that happens today. Okay, one more thing to look at since we're looking at things. Hang on a second. Okay, Sergeant Major, I have one more thing I want to share with you. It has to do with the militia. The fact that we don't have one. Now, I did a bunch of videos on this back 9 months ago or so. Right? Uncle Sam ain't released me yet. The sin of omission, classification 1H. Hey, Grunt, I'm talking to you. And in there, I was pointing out the things that I pointed out again. And we'll just go to what I pointed out again, but for a much more detailed description, that would be in these videos from some time ago now. And that was this. So this time I said, okay, I'm going to just send it right to the Supreme Court of the United States, the way it says to do, as best I can read in their rules. I had done all this before I had actually gotten the letter from the clerk denying my other attempt, which I had sent to the, which I had sent via the, I gotta go. I had actually sent one to the United States Court of Appeals for Veterans Claims, which was this case right here, 1935-37. I made the Supreme Court the respondent in a court case that I opened in this court. And I wanted to show you, Sergeant Major, this is the courtroom for the United States Court of Appeals for Veterans Claims. This court is somewhere in D.C., and they have seats right here in the audience, and I think that, you and a bunch of sergeant majors should go take some seats. And you should bring your flag and go plant it at the scene of the crime and defend the stars and stripes. Because they're not paying any attention to this stuff. Well, I don't say they're not paying attention with it. They have it. It's in their system, but they ain't done nothing with it yet. And they're changing. Right? Somebody changed the respondent and the petitioner in this case. Well, that's, this is a court record of the United States Court of Appeals, for God's sakes. Okay, so the other thing we had to deal with, let's find it here, was this right here. Okay, so I sent this to the Supreme Court. Ex parte, people of the United States, redress of grievances, offend the Constitution, proceeding under First Amendment right to petition government for redress of grievances, offending the Constitution. Registrants not properly classified in accordance with the Military Selective Service Act. In the name of the people of the United States, I, Robert Allen Mertlowski, submit this legal petition for the redress of grievances pertaining to the improper registration, classification, and examination of registrants under the Military Selective Service Act. Currently, registrants lawfully ordered to register in accordance with Proclamation number 4771, which is a proclamation by President Carter, registration on the Selective Service Act, right? So lawfully ordered to register in accordance with that are unjustly classified as 1H without their reporting to and being examined by the Registrant Selective Service System Civil Local Board and the filing of their claim. This non-claimed 1H classification results in the registrant's deserter status, loss of American nationality, legitimizes the denial of promised emergency medical care and financial aid under Title IV of the Higher Education Act of 1965, and perhaps other entitlements due properly registered, classified, and examined registrants. It appears that the Selective Service System is intentionally omitting registrants' vital entitlements, omitting vital information from official records, and as a result, the United States is without citizens or inhabitants available for unrestricted military service. Without its militia, and good faith registrants are without entitlements. In the Military Selective Service Act, which is 50 USC APP in the Appendix 451, we read, Section 453, I don't want to read the whole thing, but registrants require shall be the duty, right? That's an order of every male citizen. Well, females are males, and so are males, so all citizens, lowercase citizens of the United States, those would be American nationals, and every other male, female person residing in the United States who, on the day or days fixed for the first or any subsequent registration, being between the ages of 18 and 26, submit to registration, right? They're ordered to be registered. Who? All males, comma, / females, ages 18 to 26, who reside in the United States, whether they're a citizen or not. Persons liable for training, this is 454. That each registrant shall be immediately liable, well, that's a duty, for classification and examination, and shall, as soon as practicable following his registration, be so classified and examined. Now, I know attorneys like to say shall, well, that means sometime in the future. Brother, you ain't been in the military. Shall means shall. You shall do it or you shall be shot, is one of the possible outcomes of you denying shall. S-H-A-L-L. Shall and all. The Selective Service System in 460 says that they're going to create these civilian appeal boards, carry out the functions with respect to registration, examination, classification, selection, assignment, delivery of induction, maintenance of records, The local boards shall perform their official duties only within the county or political subdivision corresponding thereto for which the local board is established. And these boards do exist. They're just, mothballed. They're not being used, but they do exist. Such local boards shall, under the rules and regulations prescribed by the president, have the power within their respective jurisdiction of such local boards to hear and determine, subject to the right of appeal to the appeal board, hear and authorize all questions or claims with respect to inclusion for or exemption or deferment from training or other things in the title, No judicial review shall be made to the classification or processing of any registrant by local boards, appeal boards, or the president. All right, so who does say could do it? The local board, the appeal board, or the president. They get to classify a registrant. In 460, when it talks about emergency care, that under such rules and regulations as may be prescribed by the president, funds available to carry out the provisions of this title shall also be available for the payment of actual and reasonable expenses of emergency medical care, including hospitalization of registrants who suffer illness or injury, and the transportation and burial of their remains of registrants who suffer death, while acting under orders issued under this provision, under the provisions of this title. Well, they just ordered you to be classified, so you've been ordered. Right? You are under the orders of the Act by being registered. Therefore, your emergency medical care is taken care of. Now, offenses and penalties. Except as provided in G, any person who is required under 3 to present himself for and submit to registration on the selection and fails to do so in accordance with any proclamation issued under the section or in accordance with any rule or regulation issued under the section shall be ineligible for any form of assistance or benefit provided under Title IV of the Higher Education Act. So instead of getting assistance and a benefit under Title IV, you're forced to go and get a loan for your higher education. It would have been paid for had you been properly registered, classified, and examined. But you weren't. You didn't subscribe. You didn't follow the fucking rules. That's what they're saying. Right? Now, of course, they didn't tell you these rules, and they've done some things on their own to screw it up, and we'll get into that in just a second. We'll get to the proof in just a second, but let's finish up with the reasoning. In 32 CFR, Chapter XVI, 16. Selective Service System states a claim is required for classification in any class other than Class 1A. Subsection 1602.24 claim. A claim is a request for postponement of induction or classification into a class other than 1A. You don't want to be a 1A, you got to file a claim. Evidence of selective service system unconstitutionally defective records. The Selective Service System is an independent agency of the United States government that maintains information on those potentially subject to conscription. On June 25, 2010, the agency responded to a FOIA request of Ms. Sharon Rondeau regarding President Obama's Selective Service record. See Appendix. In part, the reply states, 1H has been assigned to everyone as a catch-all classification. It was not assigned to Mr. Obama as a result of any action on his part, and there is no related documentation. Let me read that again. 1H has been assigned to everyone as a catch-all classification. It was not assigned to Mr. Obama as a result of any action on his part. He didn't file a claim for it, and there's no related documentation. He didn't file a claim for it. They just did it. Assigning a registrant a classification of 1H without any claim by the registrant is not what 32 CFR Chapter 16 mandates. A claim must be filed for classification other than 1A, where it said a claim is a request for classification into a class other than 1A. The Selective Service Act mandated the creation of the civilian local boards to carry out the functions of registration, examination, classification, not the Selective Service System Director. Because this wasn't done by the boards, there's no paperwork. Somebody just did it. Well, the Selective Service System is the one keeping the records. They had to have done it. Right? It says carry out this function with respect to registration, examination, classification. Who's supposed to do that? The Selective Service System. Civilian local boards are supposed to do that. No local civilian board made the decision to classify Mr. Obama 1H. Neither did he request by submitted claim to make himself not eligible for classification 1A. And here's where the meat and potatoes are, because in 1630-15, Class 1H, registrant not subject to processing for induction, it says in Class 1H shall be placed any registrant who is not eligible for Class 1A and is not currently subject to processing for induction. Well, if you're not eligible for 1A, is that because you deserted and you're not here? Is that because you have a mental condition And so you can't pass your examination. By what choice did somebody say you're not a 1A? Because not eligible for Class 1A renders a person not eligible for unrestricted military service and ineligible to become a member of the militia or armed forces of the United States. An inspection of the registration form and corresponding registrant file inquiry report for Barack Hussein Obama evidences that other vital information required by rule is omitted on the official report in possession of the Selective Service System, where it says in that 32 CFR Chapter 16, 1615.4, duty of persons required to register, they got to give a permanent address and a telephone number and a bunch of other things. But there it is, right? If all that isn't on the record, well then either they didn't give it, which means they broke the law, or it's a Scrivener error and needs to be fixed, or it's an omission and it needs to be fixed and somebody needs to go to prison. Which one do you think it is? To submit for inspection upon request evidence of his identity to a person authorized to accept. So you got to prove who you are. It says what it is. So the registrant file inquiry report on file for Selective Service System for Barack Hussein Obama, that's his Selective Service System number, does not indicate a phone number, nor does it indicate a permanent address. It does, however, indicate an arbitrarily assigned Class 1H, signifying he is not eligible for unrestricted military service. On its face, the registration file inquiry report evidences that the future president is not a permanent resident of the United States or is a felon, as he has no permanent address or phone number reported, though both are mandated parts of the official record. Mr. Obama included his phone number and indicated a permanent residence on his registration form, but these material facts are omitted in the official report of the Selective Service System. These omissions, coupled with the admission by the Selective Service System that it is classifying everyone as a 1H, indicates that these defects are not a mistake. The Selective Service System not complying with Act of Congress is unconstitutional and could be construed as treason, and part of a scheme to ensure the United States does not have any male citizens available for the militia, to deny registrants their American nationality, and legitimizes withholding entitlements due those who in good faith registered for the draft. In the name of the people of the United States, petitioner demands the federal government of the United States inquire into this matter of national defense, declare the law, restore the nationality of registrants, and see that the mandates of the Military Selective Service Act are executed in a military manner. So help you God. Oh, God, man, there's a lot wrong in America. But here's a big one. Right, this is a violation of the Second Amendment because there is no well-regulated militia because there's nobody capable of being in the militia. And so you're denied your right under the Second Amendment to be a member of a well-regulated militia. We don't have one. Can't have one. We don't have anybody available. Everybody's a 1H. Not available for 1A. I mean, you can't participate. And so what did I have here? Here's a couple things. This was these documents I was talking about. Hang on a second. I didn't get the letter. While I was there getting the other forms for Barack Hussein Obama's Selective Service, I found this congressional record, pages H712, 714 from January 17, 2019. So I wanted to show this because this goes to how the House of Representatives did not properly take an oath of office and do the things they're supposed to. So if we were looking at this, here's the date, January 17, 2017. They're going to take a recess. After recess, they do something, talk about leave of absence. Well, then they adjourn, right? They adjourn for the day. and it says they'll convene tomorrow. House is adjourned until tomorrow, Friday, January 18th, 2019 at 10:30 a.m. Well, on that same day, the 17th, they file this thing that says they're putting the oath of office for members, residents, commissioners into the record. And it says the oath of office required by the 6th article of the Constitution of the United States and as provided by Section 2 of this Act, which is 23 Stat 22, to be administered to members, text of which is carried in 5 U.S.C. 3331. Then they give the oath of office, which says, so help me God. Right? So the oath is wrong. It's 1 Stat 23 that says what the oath satisfies the 6th article of the Constitution. And it says in there that it can't have a religious test. Well, then all these people that supposedly did this, right, they're not using their full legal name. Mike Rogers. I'm sure it's Michael, middle name Rogers. Robert B. somebody, right? Middle initial. That's not going to work. Middle initial. Not going to work. Not going to work. Not going to work. Right? C.A. Dutch Rupensberger. What the fuck is that? Right? You can't use a nickname. I mean, we just read a bit ago what the definition of full legal name is, but that's in 6 CFR Part 37.3, which is the Real ID Act. What Real ID Act says if you don't use this full legal name on your identification, you're not going to get into an airplane anymore. You're not going to get into a federal building anymore. Or it needs to be used for official purposes when dealing with the federal government. Well, all these people took an oath of office using a fictitious name, which makes their oath invalid. They don't have any authority. Back to Mr. Obama. So here's that Select the Service FOIA answer. Response to the latest Freedom of Information regarding President Obama's Select the Service records. The 1H status assigned to him at the time was not, strictly speaking, a classification. In other words, he wasn't classified. Select the Service has not classified registrants since the day the draft ended in the mid-70s. However, since that time, 1H has been assigned to everyone as a catch-all classification. It was not assigned to Mr. Obama as the result of any action on his part, and there is no related documentation. The formal description of 1H is registrant not currently subject to processing for induction or alternate service. Well, there you are. They made everybody a 1H. So here's the form that Obama filled out. Debbie Schusel somehow got this. Right now here it's got his full legal name, first name, middle name, last name. Or last, first, middle. And I would say you never have a middle name. You got a first name. Mine's Robert Allen. Anytime they got a first name box, a middle name box, put your Robert Allen in the first name box, and you don't have a middle name. Then you don't have a middle initial. He put his current mailing address, and then it asked for the permanent address, and he said, same as above. Right, and this is this thing about, well, a permanent address isn't, or permanent residence isn't necessarily the same as your mailing address, but no one will tell you what your permanent residence is. And he did put a phone number. And this shows here that no ID was shown, although it says in the Act that they're supposed to. Right, so that's what he gave them. Well, they can create this thing called the Register and File Inquiry Report. It's the PF22 or PF23 to post, whatever that means. And last name, first name, say that's how they did it. No, they said your name was Obama, Barack Hussein. They didn't give a middle name. In fact, there's no place on here for a middle name. Right? Last name, first name. There's no middle name box. Yet on the form, there's a middle name box. Middle. But not in the record. Current address, I don't know what it is. They blanked it out. But they say he doesn't have a permanent address. Well, if you don't have a permanent address, you don't have a home. You're homeless. right? So you're not found in the United States because you don't have a permanent address. It doesn't matter you're calling this current address, whatever. That's just where your mail's going to. But that doesn't mean that's your permanent address. See, they're keeping us from having a permanent address, and that keeps you from having a American nationality. Going on, telephone number 808-0000000. Is that what Obama put? 949-2317. Those don't look like zeros. How come they are in this form? And, well, last but not least, this classification, 1H. How do you get that? They just gave it to them. And so, this is the official record. So the record's wrong, but it's the official record. You go to it, it says, well, he doesn't have a permanent address, and he didn't give a phone number. This man's a felon. He doesn't get any benefits, entitlements, assistance of any kind. Where had this been done properly, and this had been done properly, and then the record, transcribed properly to make this official record, everybody who registered would have their emergency medical care taken care of and have access to funding for higher education without the need of getting a loan. It's supposed to be a grant, some kind of assistance. That's the game they play in the United States of America, to us in the United States. So this shit's got to change, Sergeant Major. Sooner is better than later. And while I probably have more that I could show you, I guess I'm tired talking about it. I need to see if anybody's going to do anything. But all these things have been taken to the Supreme Court, and you could take your flag over to their office and put it next to their flag, and you could have a talk and figure out what the hell's going on. Because once you become a veteran, well, you're just one of us. But right now, you are the man. So please go use your power. Okay, I'm going to leave it there. Everybody have a great day. Amen. We'll see you.